calling our first case of the morning is People versus Shaver. And this is a full grant, 20-minute argument on each side. You obviously know the free fire rule and the reserving time for rebuttal. So feel free to begin your argument when you are ready.
Thank you. Good morning, Your Honors. Jessica Zimbelman from the State Appellate Defender Office on behalf of Gary Shaver. I'm joined at council table by my colleague, Daniela Cohen. When Mr. Shaver was between 12 and 15 years old, he committed a registerable offense. About 10 years later, he pre-registered an address he thought he was moving to, but that fell through. As a result of that, the state charged him with failure to register under 2011 SORA, and he was sent to prison. That can't happen under this court's rule in Betts. That rule is substantive and it is simple. 2011 SORA in its entirety is ex post facto punishment. The state's rule is confusing and not simple and reads far too much into this court's rule in Betts. Essentially, what the prosecutor is asking for, from what I can gather, is that Mr. Shaver failed to report his address, and that was a regulatory provision of 2011 SORA, and therefore he should be allowed to be prosecuted and sent to prison as a result of that particular violation. What that rule would result in for this court, though, and trial courts, is a parsing out of how people violated 2011 SORA to determine whether, in the prosecutor's view or a trial court's judge view, that provision was regulatory. That is seeking to do what this court itself refused to do in Betts. This court had many options for a remedy in Betts, and it rejected them all and struck down the statute in its entirety. This court did not apply 2021 SORA as a fix. This court did not apply SORNA as a fix. This court did not sever punitive portions over regulatory portions, because as this court noted, that would be left with an unworkable statute. And this court refused to revive a prior version of SORA. So what this court did was issue a simple, substantive rule that 2011 SORA in its entirety is ex post facto punishment. This prosecutor is seeking to overrule this court's decision in Betts through a retroactivity question, and that is not proper. It is a substantive rule, as the prosecutor acknowledges in their briefing, that ex post facto violations are normally a substantive violation or a substantive rule. But then the prosecutor...
Can we, not to interrupt your flow, but to jump ahead a little bit, let's say I agree with that part of it. To jump ahead to the administration of justice angle, at first glance, it seems like the easiest piece of this, where compared to other cases where they might have to be retried, this is one where it's unlikely that any of these individuals would have to be retried, or that the administration of justice angle is much simpler than other retroactivity cases. The problem that I'm dealing with, or the problem that I'm seeing, is if you have individuals who had a conviction for a SORA violation that was valid at the time, and then they had some other offense that affected their PRVs on some sentence beyond that, what do you envision being kind of that trajectory of those cases?
That's an interesting question, Your Honor, and I have litigated these cases in the years since the Betts decision, whether somebody could be counted as sentenced as a habitual, scored under the PRVs, based on an unconstitutional conviction. And it is a simple administrative remedy here for these convictions. It's a discrete period of time, about 10 years, July 1st, 2011 through March 24th of 2021. That's the time period we're looking at in the violations. It does become more complicated for people with subsequent convictions whose sentences may have been enhanced based on an unconstitutional conviction.
Right.
I think those would be very fact-specific circumstances, but the burden would be on the person challenging that conviction to work with the prosecutor or the trial court to get a stip in order to vacate that unconstitutional conviction in the first instance. Then we can address, possibly through a 6500 motion, if their subsequent sentence on an unrelated offense was enhanced by an unconstitutional conviction. That does become more procedurally complicated, but any future challenges to a sentence on an unrelated I think that would be a limited number of people, and a limited number of procedural routes available to them to challenge a subsequent conviction if it was enhanced by a failure to register felony.
Okay, all right, thank you.
Counselor, I have a fundamental question about our record. Is this an adjudication or a conviction? And it matters because I think there's some question around the timing of the offense. And so the breadcrumbs that I could find in the record, and maybe you can tell me which way this goes, since it's referred both ways. We don't have an order of adjudication or conviction from 2004 in the record that I could find. There's one document that says the defendant is committed to a juvenile agency, but uses language of conviction. There's, which has an FC suffix, which suggests it might be an adult conviction. There's the document that you've cited in your brief that says that it's a conviction and then a juvenile sentence. But then there's the 2016 PSI where initially he was scored for an adult conviction, but it was crossed out, and then he was scored instead for juvenile adjudication and not an adult conviction. And so do you have any other sources in our record of what is actually the underlying case?
I don't, Your Honor, and you've summarized it quite well. From my review of the record, it appears it's an adult conviction with a juvenile sentence. The prosecutor and I have, over the years that we've been litigating this case, I think collectively bemoaned the lack of a clear record here. But my understanding is that Mr. Shaver pled guilty to an adult felony conviction that caused him to register, 3 counts of CSC third.
And you agree that if the offense was in 1998 and it was a juvenile adjudication, he actually wouldn't be required to register anymore?
Yes.
So it matters.
It matters. I think it makes it even more clear that this conviction for failure to register is improper, and perhaps takes us out of the Betts context entirely. But what we have and how we've litigated this case up to this point is that it was an adult conviction, and much like Mr. Betts himself, Mr. Shaver can't be punished for violating a statute this court to be found to be ex post facto punishment. I'm going to save the rest of my time for rebuttal unless the court has any more questions right now.
May it please the court, Eric Kostusha from the Attorney General's Office, appearing on behalf of the people. This court should rule that the decision in Betts does not apply to cases that are final on direct review, where the defendant was convicted for the failure to update his address under the 2011 SORA, because it did not, in the words of People v. Poole, place certain laws beyond the state's power to impose. Shaver's conduct was a crime then, and it's a crime now. There's nothing unfair or improper about sustaining Shaver's conviction for his willful failure to update his address in 2015. The only reason he would prevail in direct review is that this court rejected the argument that it should sever the problematic features, that is, certain parts of the 2006 and 11 amendments of the 2011 SORA law, from the clearly regulatory provisions, such as the one at issue here, which is a basic duty has been in place since 1999. It is true that the pre-2011 law provided him 10 days in which to update his address, not 3, and that he did not have to do so in person before 2011. But neither of these differences in 2011 had any bearing on his conviction, as a plea colloquy here makes clear. And the provision to update one's address is regulatory anyway. A ruling on severability says nothing about the constitutional validity of the regulatory provision to update one's address. Shaver's not entitled to relief as a matter of federal and state law. of retroactivity. There are two metrics under the state rules of retroactivity. Substantive rules are constitutional guarantees that place certain criminal law beyond the state's power to impose. That's not applicable here. Betts did not place it beyond the state's power to require a sex offender to have to update one's address. Under the federal rules of retroactivity, the concern for substantive rules that there may be an innocent person sitting on a conviction for conduct that the law does not make criminal. That's also not applicable here. The law required Shaver to update his address in 2015. He knew the duty, and he willfully failed to abide by it. Before I move into the substantive arguments, there's one correction I'd like to make. On page 25 of the merits brief, I suggest that the pre-2011 SORA included a duty to update one's address in person. That's wrong. The in-person element was added in 2011, as noted on page 8 of the merits brief. It was the periodic reporting that was in person before 2011. I regret the error. But this doesn't affect the fact that the duty at issue here is regulatory.
Counsel, so I agree with you that Betts didn't deal with the particular address issue that we are looking at today. But we also made it pretty clear we weren't going to engage in the severing analysis, that there was just too much, that the statute had a major overhaul and we couldn't pick and choose elements of what should be saved and what shouldn't. So can you help me understand why we should, at least in this case, I guess, engage in that analysis?
Well, it turns on the federal retroactivity analysis, and I should reference the fact that it creates a floor. I mean, you really don't have to get to the state regulatory, the state retroactivity standards if it's found to be a violation under federal retroactivity laws. That really is the end of the inquiry. So the standard is a rule is substantive rather than procedural if it alters the range of conduct or the class of person that the law punishes. So that's the question. So the question is, what does it mean to alter the range of conduct? And the cases that we both are citing, both Mr. Shaver and the people, are this Welch-Johnson combination of cases and Bowsley-Bailey combination of cases. That's for the narrowing. So in Welch, it had to do with the definition of violent felony in the residual clause and would elevate the punishment. The court found it to be unconstitutionally vague because it fails to give ordinary people fair notice. And so someone had been sentenced under that on something that was unconstitutionally vague. And in Bowsley was kind of a comparable thing where it had to do with the use of a firearm. And the question is, what does use mean? And the court in Bailey had said it's active employment of the firearm. So you had Mr. Bowsley who claimed that he just possessed it. So he essentially pled guilty on something that wasn't a crime. The insight in both of those cases about the narrowing is that you had people who had been convicted for conduct that the law did not encompass. Essentially, they were innocent. That's not true of Mr. Shaver. And that's the point here, is that he knew about his obligation to register in 2015. It was encompassed within the law. He was on notice. And he willfully failed to abide by that. And I do want to, I have in my back of my mind, I want to address Justice Thomas's point. I think that's a threshold issue. But setting that aside for the moment, he knew about the obligation. So consequently, this concept of the narrowing is not joined by the Betts decision. Betts ultimately was a ex post facto analysis, but a very unusual one. Right? In the ordinary case, there's a sentence, and then or a possible punishment, years of in prison, and that statute changes. It goes from a 10-year to a 15-year. Someone commits the crime, and then the statute changes and then given a higher sentence. Well, here, I mean, the sentence for the crime that Mr. Shaver committed didn't change. It was the regulatory obligations. And at some point, there were so many new obligations imposed that the obligations went from being regulatory to being punitive. That's a very unusual ex post facto analysis, right? So that's kind of the point about the hypothetical I provided to the court. If you had, a statute that had a 1A, which was regulatory, and a 1B that was punitive, and the court found it not to be severable, so 1A couldn't be applied, but 1A is a constitutionally valid provision. Ultimately, the reason I'm pressing this is that the federal constitutional retroactivity analysis invites this kind of inquiry, because the basis of the narrowing has to do with this fear that you have an innocent person sitting in prison. That's not true of Mr. Shaver. He obviously would get relief on direct review, but that can't be the only analysis that's relevant for the question of whether he gets relief on collateral review. So that's kind of the first part of the test. I mean, the second part is both the state rule, which also exists in the federal, which is the state's power to impose. The question is, and this I think for me is the nub of the thing, can the state impose the duty to update one's address? And I think here it's important to know that in 2011 it was in person within 3 days. Is that a regulatory provision? And if it is, then the state has the power to impose it. The state's obliging people to do that right now. In other words, this duty to register one's address, it is a core part of the registry. I mean, the registry really can't function without people updating their address, because that's the way in which the ordinary application of the registry is people look and find the address of where people live. In other words, though, if this is a regulatory provision, the idea that someone has to get relief on collateral review doesn't make sense, because it's within the state's power to impose. And that's the standard that this court uses for its own retroactivity analysis. And also it's part of the floor for the federal retroactivity analysis. And anyway, so the digest of that answer is, the reason I'm asking the court to engage in this inquiry is this is what the federal retroactivity analysis suggests, because the metrics are, is there a person who's actually innocent of the crime sitting in prison, or is it outside of the state's power to impose? And neither of those are true for Mr. Shaver with respect to his duty to update his address. Now, I do want to jump in on Justice Thomas's point, because really, the thing, Justice, you flagged, I've been aware of, because my understanding is this was a juvenile adjudication. In fact, I know because there was some litigation separate from this case in Ray MD, in which that issue was raised. It's the state's position, and if the state's wrong, I guess I should say one thing further. There's been some question, because the record below was difficult, and one of the things in which we entered a stipulation, which is outside the record here, but it's on the record in the Court of Appeals, is that Mr. Shaver was 15 years, 4 months at the time of his registrable offense in 2003. So we know his age.
The
Go ahead.
record that I see is that it was in 1998, so is there something in our record that supports that stipulation?
Yeah, so I have that. I mean, that's the stipulation was entered on the record in the Court of Appeals. It appears that on the March 12, 2024 argument, if you go to the audio and you double-click it, you'll hear me saying this at the 48-second mark up to the 108-minute mark. So in fact, we had an email exchange about this, and I have Jessica Zimmerman's email about this. Anyway, the only reason I want to clarify is it helps kind of further address your point. He was 15 years old, and that's relevant because if he had been under the age of 14, the SORA was changed in 2011 to create 14 as a floor. So if you had someone under 14 who had to register before 2011, they would have no obligation under the SORA under 2011 at all. So if he had been under 14, there could be no conviction. But that's not the point you're raising.
So your position is that it's an adjudication, but he was 14 or over?
He was, but there's still the question, and this is outside of any of the briefing here, and the only reason I flag it is because the question you're asking is, there was a change in Michigan law in 2021, which affected also juvenile adjudications. My understanding is this is a juvenile adjudication, so it's not in the public registry. He is not, so if I put in Gary Shaver and I go Michigan Sex Offender Registry, I'm not going to find him. So it's a non-public because it was a juvenile adjudication. There was, in this other case, this court remanded to the Court of Appeals, ultimately it didn't reach the issue about whether post-2021, it's the position of the people is that no longer do juvenile adjudications have to register. But there was an argument advanced, in fact, you were the advocate on that case, there was an argument advanced that for the prior 2021 registrants who were adjudicated, that they no longer have to register based on the change in law. This has not been briefed here. The only reason I flagged that is that...
No, I'm not flagging that.
Okay, that wasn't it. I'm sorry. I thought that was the issue you were raising.
No.
Sorry.
But it appeared from the record that I could see that his offense was in 1998, which would have made it
Right.
under 14.
So no, so the offense date here is...
That's the piece I'm trying to figure out.
Right, so the offense date here, as we placed on the record, was November 3rd, 2003. And he was, and with his date of birth having been, is July 27th, 1988, that would make him 15 years, 4 months.
I have another threshold question for you.
Okay, thank you.
So the question we asked is the application of retroactivity doctrine. And you've argued, based on that, but in looking at ex post facto claims, there's very few cases that apply retroactivity doctrine, and I'm struggling with the nature of the claim. Like, so Collins versus Youngblood suggests that it's appropriate to apply Teague when looking at an ex post facto, but doesn't there. And then the other case that I could find that applied a retroactivity doctrine is the Alaska Intermediate Appellate Court, when they found their registration was punitive. What other cases should we look to that say that this is the appropriate lens through which to ask the question, or is there something unique about an ex post facto violation that it doesn't need to go through a retroactivity analysis?
I think, frankly, that the retroactivity analysis for ex post facto in the ordinary case would be straightforward. In other words, if this were the case where Mr. Shaver had committed an offense and the penalty at the time in which he committed his offense was a 10-year felony, and then there was a change in law and made it a 20-year felony, and he then was given a 20-year sentence and was serving a sentence that it was a change in law after he had committed his crime, I think he would be entitled to relief. He would be essentially serving a sentence that wasn't authorized by law. In fact, I think this court's analysis applying the dual sovereignty doctrine, Cooper was the underlying case, why the name is escaping me, about the court in which this court's decision in which it said that had to be applied retroactively. I think in the ordinary ex post facto case, it would be a pretty straightforward case that the defendant would be entitled to relief. I think the thing that makes this different, and the reason I've been pressing it, is that there are all sorts of people who, under the 2011 SORA, committed violations of the regulatory part of the law which were clearly valid, and whose convictions, whose conduct would be a crime now and was a crime then. I mean, that's the anomaly I'm trying to point out to the court. Think about this. Let's say he's convicted before 2006 for the SORA violation. This court's analysis is that the 2006 and 11 amendments made this SORA punitive, so the 2011 SORA is punitive. Prior to 2006, it had been found constitutionally firm. So let's say he commits his offense in 2003, and then he fails to register, fails to update his address, as he does here. He's validly convicted. It happens in 2015, it's invalid. Happens in 2022, it's valid. That doesn't make sense. I mean, he's entitled to relief on direct review. I get it. But the question is does the federal rules of retroactivity say he's essentially an innocent person? He's not. Is this something outside the state's power to impose? It's not outside the state's power to impose. That's why the ex post facto analysis, I think, when you point to other cases, is very difficult, because it really has to be essentially something within this realm, it seems to me. Because if you look at the way the Welch, Johnson, Bowsley, Bailey case run, or I guess Poole is also the other analogy I think is worth touching on, because that talks about class of offenders. I mean, really the argument being advanced here is there's a class of offenders. It can't be applied to them. That's the pre-2011 SORA registrants. So, it's easy. You know, the state loses, people lose. But that's not really the case. I mean, really, if you look at it more carefully, Poole said essentially everyone sentenced was given an unconstitutional invalid sentence, automatic life without parole. Here, it's a mixed group, right? The pre-2011 offenders, some violated things that are purely regulatory, and some violated things that were ultimately what made the registry punitive. Seems to me, with that mixed group, it's what makes this different than Poole. Poole, everyone was entitled to relief because everyone was sitting under an invalid sentence. Here, you have a whole set of people, I think including Mr. Shaver, who violated a regulatory obligation.
Can you point us to anything where there's sort of this, I'm going to call it as-applied retroactivity, right? It sort of has that, like, we're sort of looking at an individual case versus the nature of the claim and the facts of the situation.
I don't have any cases that are like this, because in a way it feels to me that we're in a, you know, the idea of ex post facto being applied in the Sex Offender Registration Act in the first instance itself has its own level of complexity, right? That to say all these things are regulatory and then we have these additional obligations and this is what makes it punitive, that's a very different kind of ex post facto analysis. I mean, I do have a case site where someone was given a contempt and it was clear that it was an increase in punishment. It was a fine that hadn't been authorized by the statute. But that's not what this is like. So I guess the short answer, though, is no. If I'm asking this court to point to some other, it is not clear where else to go to look at this other than the basic principles, which I think are clear. I mean, I think the standards at issue are, at least for the federal rules of retroactivity, right? Is the person actually innocent? Is it outside of the state's power to impose? And assuming that the court says, oh, you know, the people are right on both those things, well, now let's go to the state rules. Let's go to the Hampton factors and go through this three-part test. And I think Justice Hood brought out the fact that, you know, there are a large number of offenders who would be entitled to relief. It seems to me like we know the number of cases that were pending. We have those lists of the people who were sitting on SORA convictions, those who had parole violations. I mean, that was in the hundreds. But the number of people who were convicted over that time period are in the thousands, right? And so in concept, all of those people could then come back and seek to set aside their convictions, or if they were habitualized, challenge the habitual, or if there was a PRV, challenge the PRV, right? So it's not like this is just a small number of cases. It's a large number of cases. And so when the case has reached finality on direct review, the basis for the claim for relief has to be the strongest. And I think that's why I think, for me, the fairness part of this has always seemed the easiest to talk about. I'm not troubled by the fact that Mr. Shaver has this conviction because he knew about the obligation. I think the obligation is constitutionally firm. He failed to abide by it. If it happened pre-2006, he'd have no claim. If it happened post-2021, we would still bring forward the charge. He would be convicted. But since it happened during this window of time, because ultimately the basis for this court's decision for why this would not be able to be sustained was based on its severability analysis. And the severability analysis is not something that showed that this provision, the duty to update one's address, is somehow outside of the state's power to impose. And so when you look at the considerations, because that's another thing too, is, you know, one of the arguments has to do with reliance. If this court had ruled earlier, let's say, because that's at the time at which it ruled, the statute had already been amended. The legislature has been very attentive to this law. If this court had ruled earlier, the statute, I think there's reason to believe, would have been amended. In other words, the duty to update one's address is going to stay within the registry. It is such a basic component. There's nothing improper about requiring someone to update one's address. It is a basic feature of the registry. It's true of virtually all the registries. Obviously, Michigan's law now is virtually on all fours with the federal SORNA. So my point about Mr. Shaver is what should drive the state retroactive analysis once you get past the federal retroactive analysis is why would we upset our convictions that have reached finality for conduct that itself is things that we can impose. He had the obligation. He knew about it. There's no unfairness. This isn't like Poole where everyone was improperly and invalidly sentenced, or Welsh where, I've been, sentenced under the residual clause, which is vague, or Bailey, and Bowsley, where, what I did wasn't even criminal. My use of firearm was just possession, and that's not governed within the statute. I'm sitting on a conviction for something that wasn't criminal. That's not true here. Mr. Shaver willfully violated the law and pled guilty. And if it happened before 2006, it would be perfectly fine. And if it happened today, it wouldn't be a problem at all. But yet, because it happened at a time in which the court was unable to sever the law, that's the reason that he would be able to obtain relief. That's not a basis in which to grant him relief on collateral view. So the people would ask that you affirm.
Thank you.
I'm going to, begin by responding to you, Justice Welch, that this court in Betts did not address address reporting. This court, in fact, did, twice. In one part of the court's analysis about in-person reporting, this court said, upon numerous life events, including moving residences, and then went on to discuss the burdensome nature of in-person reporting, which was a large factor in this court's analysis about why SORA was punishment. And then, again, this court said, cumulatively, these frequent in-person reports imposes a burden on registrants. So while this court did not explicitly say address reporting is regulatory in nature, it did bake it into its analysis about the punitive nature of the statute. And the prosecutor said there's nothing improper about address reporting. Maybe if that's all it was, that would be true. But as this court acknowledged in Betts, what SORA has become and what that address reporting means turns it into something different. That address is publicly posted online where people can harass registrants. And this court went to great lengths to explain the problems with the public nature of the registry. And of course, in-person reporting being burdensome and requiring that within 3 days of an address change. So I won't concede that address reporting is merely regulatory and that there's nothing wrong with punishing somebody because of that. The prosecutor also focuses on, or asks the question, can the state impose the duty to require a registrant to report their address? That's not the proper question for this court to focus on when looking at whether Betts should be applied retroactively. It is whether the state can punish Mr. Shaver for failing to abide by a statute that this court declared unconstitutional ex post facto punishment. And the prosecutor focuses a great deal on the conduct here. It's always been a crime. It still is a crime that you have to report your address. But the retroactivity jurisprudence from this court and from the United States Supreme Court, when defining a substantive law, does focus on conduct. But then it also says you cannot place particular persons covered by the statute. You can't apply it retroactively when it's beyond the state's power to punish. So again, we're talking about the state's power to punish here. And I think that this court should hold today, for the first time, it is a rare situation about the retroactivity of ex post facto punishment. This court should hold that ex post facto punishment should be retroactively applied as a bright line rule because of the nature of ex post facto punishment. And this isn't different or complicated because it involves SORA. The prosecutor might not like this court's holding in Betts that SORA is punishment, 2011 SORA is punishment, but that's what this court held. It's just like any other punishment. You can't retroactively apply it. The prosecutor also talked a great deal about fairness. It is not fair that Mr. Shaver went to prison and spent a great deal of time there and will go back. He was solely incarcerated because of his failure to register conviction. He will go back to prison if the Court of Appeals opinion is affirmed. Mr. Betts was charged with failure to register his address, in part, and email and vehicle requirements. But that exact same conduct that this court found for Mr. Betts was unconstitutional ex post facto punishment is what Gary Shaver did. He wasn't malicious in his failure to report. This court has acknowledged the complex and confusing nature of the sex offender registry. It's hard for us as lawyers to understand it. Mr. Shaver tried to do the right thing. He was gonna move, he reported it, and it fell through. So to consider sending him back to prison for the very same conduct that this court found was punitive for Mr. Betts, that is what is unfair. I asked the court to reverse the Court of Appeals opinion and hold that this court's clear, simple, substantive rule for Betts is applied retroactively. Thank you.
Thank you. The case will be submitted.